Jacqueline Bhabha, and I'm one of the co-organizers of this meeting, and it's my job to open the proceedings today. We're delighted to have all of you here, and what I thought I'd do is just make a few opening remarks, and then we will move on with the agenda as published. So, this is a very, I think, useful occasion for those of us who don't always spend time in India to listen and learn from our colleagues who are here. And we hope also to exchange some information that might be of use and contribute to the movement to address and eliminate, ideally, gender-based violence. I thought what I would do briefly is to simply make 4 points, and then we'll hand over to the main speakers. My first point is that I think many of us would agree with one of the key findings of the remarkable Verma Committee report, that the key problem we face is not a problem of law, but a problem of implementation. Now, that is not to say that there aren't issues around legal definition, legal capability, legal exclusions, which don't need attention. Of course there are, and we will be addressing those issues and discussing them in the course of this conference. But the first point we wanted to make is that we see this occasion as an occasion for really thinking seriously about the way forward. We do not want this simply to be an academic talking shop, though clearly at the moment that is what we are in this room. We want to try to use our best endeavors to contribute to building the civil society presence and activism that's going to be required to move forward from the initial protests that took place around the turn of the year. Now, to say that implementation is the main problem is rather simplistic, because implementation, of course, is a multi-headed dragon. It raises all sorts of questions about responsibility, about transparency, about accountability, about mobilization, about political will, that are complicated. And one of the reasons why, not only in India, but in many of the societies we work in, implementation lags so far behind legal provisions is because that set of provisions, that set of factors is absent. So I don't think I'm saying anything new here, but I did want to start by emphasizing that that is where I think our job lies. That is really the homework that many of us see ourselves as having, how to move to a space of greater transparency, how to move to a space where public officials are held accountable, where they feel that they're going to be rewarded for doing the right thing and maybe punished for doing the wrong thing, rather than a sense of indifference or indeed a sense of complicity. My second point is that for our event today, as you know, we have chosen 3 themes, 3 interlocking themes. These are not 3 separate silos, as it were. All the themes are going to affect each other, but for purposes of clarity and simply to make the conversation logical and smooth flowing, we have identified 3 main topics. The first topic concerns legal enforcement, concerns questions of the definitions of sexual coercion, it concerns questions of legal scope. And I think we have a wonderful set of panelists here who are going to address some of those questions, and I'm sure the audience too is expert and will contribute thoughts on this topic. There are many issues, of course, which have been raised and which are complicated, issues to do with marital rape, issues to do with the age of juvenile responsibility, issues to do with the exact definitions of some of the acts of sexual coercion, and we may well not all agree, and that's certainly the point of a collegial setting like this, to disagree in a respectful way, and I hope we are able to do that. But I think those questions will certainly be what kicks us off in our discussion. Our second point of focus is civil society initiatives. And here, of course, we are not going to list or be able to refer to all the interesting, innovative, and committed work that's going on, but simply to highlight some of the most original ideas, some of the most challenging thoughts that perhaps can inspire us as we move forward. So again, the idea here is not to make a hierarchy of merit or to give medals or anything like that. It's simply to provoke a creative discussion about change with some very concrete examples. And we're very grateful to our colleagues who've come to share their experience that they've done this so that we can learn. And I should say in this context that many of us, and certainly my colleagues too who've come from the States, have been active in the women's movement for decades. And so many of the problems that are faced here in India are very similar, of course, to problems that arise elsewhere. There are some specificities, but there are many, many commonalities. And so we hope that in the spirit of exchange, we'll learn from some of the developments here, and maybe we can contribute some ideas and thoughts and questions of our own. And then finally, our third panel will relate to questions of curriculum, schooling, conceptions of masculinity and femininity as they manifest themselves within the classroom amongst young children and adolescents. And this, to our mind, is a critical ingredient of this whole discussion, because violence, brutal violence, barbaric violence of the sort that precipitated this conference today, does not just come out of nowhere. It comes embedded in social structures which enable it, which create it, which generate it. And so we know, of course, that some of the accused had dreadful histories of being recipients of brutality themselves. They were brutalized and they became brutes. And so we have to analyze and try to correct these processes of brutalization. And one of our ideas is, if there's a consensus and if people think this is useful, sorry, I'm only looking at one side of the room, one of our ideas is that really prevention is where we would like to put our energies in a big way, and thinking about contributing to the already vibrant moves to introduce new curriculum, and to thinking about ways to support teachers who are dedicating their lives to trying to create better discussions and better relationships within the classroom, is something that that really falls within this discussion. So just very briefly, those are the three areas that our meeting will formally focus on. As I said, they are not discrete areas, and so I'm sure that as chairs, those of us who are chairing, we will exercise judgment and enable a productive conversation, even if some of the comments come from slightly left field. But we really hope that this leads to some contribution to what's happening on the ground within government, within the civil society movement, within the women's movement, amongst those who support survivors. The last point I want to make is that no event like this, especially for those of us who are based most of the time abroad, happens without a lot of work on the ground, without a lot of collaboration and goodwill. And I do want to recognize and acknowledge at the outset how indebted we are to our colleagues here who've partnered with us, who've done an enormous amount of work and put their, not only their money where their mouth is, but also their hearts and their time into creating and enabling this event. We think this is an important event, not because it's unique, not because it's anything over and above other events, but because it is an opportunity to bring people together, to carry on the conversation, to carry on the sort of scrutiny that these issues deserve, so that we don't slip into indifference, so we don't slip into a sense of, well, and now it's all over, and so then what? And so we're very grateful to our colleague Aparna, who is somewhere in the room, who's right here, who is our partner, who contacted us, so to speak, out of the blue, and simply said, you know, I am a Harvard alum, I care about this issue, what can I do to help? And nobody could have done more to help than you have, Aparna, so thank you. And our colleagues, yes. And our colleagues who are based here in India at the Harvard office have been stalwarts and extraordinarily willing to help at every last second and run around and do things for us. And without them, I don't think we could have pulled this off and organized this event. I want to thank Mr. Soli Sorabjee, who helped us very much in the early phases book this venue and facilitate our presence here at the Indian International Centre, a revered place for this sort of meetings. So thank you very much, Mr. Sorabjee. And finally, and last but certainly not least, I want to thank the energetic and passionate and committed Harvard students who really set us on this course, because it was Harvard students, many of them from South Asia, who insisted at the very beginning of the semester that started after the December 16th rape, who insisted that we have an event, who insisted that we pay attention to this issue, who insisted that some of us on the faculty make time to address the questions and the tragedy that we saw unfolding. And so I think we really owe a huge debt of gratitude to our students. I think only one of our student representatives is here. Here she is, Sabrine, but she represents the group very ably. So Sabrine, on behalf of all of you, thank you so much for what you did for us. So now I think the next order of business is to introduce Mr. Gopal Subramanian, who, as you all know, is a former Solicitor-General of India and who is one of the 3 members of the Verma committee. Mr. Subramanian has very kindly agreed to pay a tribute to Justice, Chief Justice Verma, whose image is there. And so, Mr. Subramanian, thank you so much, and over to you.
Justice Jagdish Sharan Verma was an extraordinary man who was characterized by his integrity and his insistence on the standards of appropriateness which he felt must be maintained at all points of time, both while holding public office and after demitting it. Justice Verma grew up in Rewa and later became a leading lawyer in the Madhya Pradesh High Court of Jabalpur. He learnt civil, criminal, and constitutional law and was appointed as a judge of the Madhya Pradesh High Court by virtue of his merit and his knowledge of law. Like his mentor, Justice Singh of the Madhya Pradesh High Court, Justice Verma, in addition to being a hard worker, subtly inspired others to work hard. This was something that I saw during the Commission of Inquiry to examine lapses of security that led to the tragic assassination of Rajiv Gandhi, and also when he undertook a review of the laws relating to women and in particular criminal laws. While Justice Verma represented corporate clients as a lawyer, but he never compromised the ethical standards of professional behavior. In fact, corporates sought him because of his integrity, and he then left a lucrative practice to become a judge. As a judge, Justice Verma shunned pomp and pageantry. He lived an austere life and was open to new ideas, decisions, and was very fond of writing important passages in his judgments by hand. He always felt that he was publicly accountable as a judge and believed that decisions of judges must always stand up to appellate scrutiny as well as public scrutiny. He also upheld the independence of the judiciary when the executive wanted to appoint its nominees to the court, and he believed that a truly representative collegiate system which would work for the impartiality and dignity of the judiciary would serve that purpose. He also was aware that the best of judgments rendered with the best of intentions may often need a review and a mid-course correction. Justice Verma was fundamentally governed by 2 ideals. First, the ideal of the Constitution, and in particular the protection of citizens at all points of time and minimal invasion of their rights by the state. Secondly, he was conscious that in a society where consciousness about rights is still evolving, those who needed special protection, like women, and particularly against crimes such as sexual harassment, evolved by means of extraordinary judicial interpretation, new tools. Once during an Indo-US judges exchange, Justice Scalia of the United States Supreme Court greeted him by saying, "Chief Justice, is there anything you can't do?" And Justice Verma replied, "Yes, I can't sit and do nothing whilst people are denied the basic rights and guarantees given to them." In Nilabati Behra, he took forward the theory of awarding compensation for violation of fundamental rights. His legendary guidelines in Vishaka were based upon an amalgamation of Articles 14, 15, 19(1)(g), 21, 32, along with, shall we say, the various international covenants. He relied on Articles 51a, 42 and 51 of the Constitution to indicate that those concepts of international law which are germane to constitutionalism could well be adopted by the court as independent values. In Vineet Narayan's case, he recognized the role of constitutional functionaries, including the Attorney General, as the custodian of public interest. In Vishaka, Justice Verma clearly felt that there was a legislative void, and until that void was filled up, society needed to develop mechanisms to ensure that working women were not exposed to threats that affront their dignity and offered judicial succor. Justice Verma was able to perceive that women in India are equal partners in growth, and they could not be left vulnerable at workspace merely because legislators could not spend time to put together legislation for their protection. In Vishaka, he brought the paradigm of gender justice at workplace into the center spot of globalizing India, making the workplace more amenable to women's participation. Justice Verma made an assiduous effort to learn and understand the traditions of the court and the bar from every possible source. He regularly discussed and debated upon these traditions with his brethren in the legal community and many retired judges. But most importantly, he believed that the need for separation of powers and judiciary always being at arm's length from the executive was completely fundamental for constitutional governance. But more importantly, he believed in the potential of young people to bring about change in society and the law. After his retirement as Chief Justice of India, he constantly moved around the country and involved himself in teaching, lecturing, and discussing with students. He believed that the next generation could remedy the problems created by the previous generations. In fact, Justice Verma was wrapping up a lecture series to law students at the Government Law College at Mumbai when he was hospitalized. We lost him prematurely and in somewhat the most unexpected of circumstances. As he told me very frequently, both at the beginning of the work and when I visited him at the hospital, that the Verma Committee's work and its report is simply just the beginning. The work has to be carried on, and it does not matter who carries on the work. He hardly cared for himself or his individual self or ego. For him, it was important just to act out of principle. With his loss, the legal fraternity in the nation not only lost an outstanding Chief Justice, there are some men who by sweat, toil and sacrifice and personal conduct have fed their vitals into the institution. The only way lawyers and judges can ever pay a tribute to him is to live some facet of their life like Justice Verma would have expected them to. His hard work and dedication, work of the committee to review criminal laws in the aftermath of the December 16 rape is a feat which I think is unsurpassable. He was able to discuss multiple issues of law, philosophy, psychology, and above all, even psychiatry. We decided as members of the committee that not only would we base our conclusions on the recognition of human rights, but would bring to bear an interdisciplinary approach to the rights of women. His progressive outlook towards life and societal change was demonstrated by a fact which many of you may not know, that his last rites were carried out jointly by his grandson Anirudh and granddaughter Preetika, both of whom are here. In line with the recommendations of Justice Verma and with the thrust of this conference on the inclusive perspective of criminal law, good practices and curricular reform, and, shall we say, overall in the context of promotion of gender justice, wherever Justice Verma is, I'm sure he would be happy to see us putting our best foot forward. He was a great judge and, I would say, a greater human being. His favorite quotation, which he would tell me, was what Joseph Addison said: "To be perfectly just is an attribute of the divine nature. To be so to the utmost of our abilities is the glory of man." I very respectfully join all of you in paying a tribute to the chairman of the committee, without whose indefatigable labor and his extraordinary spiritually directed endeavors this report could not have been accomplished. Thank you.
Mr. Subramanian, thank you so much for that magnificent tribute. I think you set us on a perfect course for the next day and a half. The idea that the work is just beginning and that such a remarkable figure, such an erudite and at the same time human and simple figure should have sort of launched us on this way is really a wonderful, wonderful opportunity for us to move forward. So thank you for those wonderful words. I'm delighted to now introduce our next. Sorry. Oh, sorry. We're going to light the lamp. So excuse me for a second. We'll just wait while that happens.
Where are the two grandchildren?
Where are the grandchildren? Are they here? Are the grandchildren here? Pardon? Yeah, I think, yes. Shall we just wait? Because I think that Chief Justice Seth is also going to pay a tribute. So maybe shall we light? Okay. So it gives me great pleasure and it is a great honor to now introduce Justice Leila Seth, who is the former Chief Justice of Himachal Pradesh and who is a second member, another member of the Verma Committee. We're really very delighted and grateful that you are with us today, Madam. And I'm now handing over to you to make your comments. Thank you.
On the night of 22nd April 2013, I was shocked to receive a call from a TV channel asking me my reaction on Justice Verma's death. I did not know what to make of it, as I was not even aware that he had been ill. I had last seen him a week earlier on 15th April at the NDTV function, Indian of the Year, as they were honoring Nirbhaya as India's daughter and us for the report following her horrendous rape and death. He was there with his daughter and granddaughter, and I was there with my spouse. After the function, we stayed on for dinner, and we were relaxed. He looked well, and when I asked him, he said he was fine, but a little tired. I told him, don't take so much on, and don't travel so much. He smiled, and he said he enjoyed talking and traveling. Before working on the Justice Verma Committee, I knew him by his reputation and judgments. He was a forthright judge. Mr. C.K. Daftri would have been pleased. When I became a judge in 1978, the well-respected octogenarian, senior lawyer, gave me sagacious advice. He said, there are 4 types of judges: the timid judge, the differing judge, the academic judge, and the forthright judge. Be forthright. And that's what Justice Verma was, forthright. Justice Verma believed in coming to the point and did not indulge in academic erudition. He wanted to give substantial justice, and this is apparent from his decisions. In this connection, let me mention 2 of his well-known judgments, the Vishaka case and what came to be known as the Jain Hawala case. In the Vishaka case, 1997, he tried to find a remedy for sexual harassment in the workplace, as there was no law to prevent this. He even looked at foreign law and treaties and set out certain guidelines to be followed till legislation was passed. This helped many to overcome the societal evil, till the law was passed only 16 years later in 2013.
Has been passed.
Yes. In the Jain Hawala case, as Seema Chishti has said, he raised the bar for handling corruption cases. He brought about the constant monitoring of by the court of the police and the Central Bureau of Investigation, the CBI, which came to be known as continuous mandamus. As Chief Justice, he ensured that the voluntary code of conduct for how judges should behave was agreed to and assets declared. It was called the Restatement of Values of Judicial Life. Ever optimistic and hopeful that things would improve, he was a positive person. He was also willing to accept that certain of his judgments may need reconsideration, such as the collegium system of judges appointing themselves. When I was asked by Mr. Chidambaram, the finance minister, to serve on the committee after the Nirbhaya rape incident, I asked him who was to be the chair. When he said Justice J.S. Verma, I readily agreed. I knew of him as a courageous, independent, and honest judge. It was a great experience for me to work with him, always courteous, always smiling, and wearing his twin-colored scarf to keep out the winter cold. He worked tirelessly and anxiously to ensure a good, comprehensive report, and in time. May his tribe expand, and may his soul rest in peace.
Thank you very much for those moving comments and for that picture of this remarkable man who you work together with. I must just say that from the perspective of the legal community at large, seeing the quality and the eloquence of that report produced in just 30 days was inspiring, and it just made one realize that where there is a will, there's a way, even in situations where one would think it was impossible. So really, I think I speak on behalf of many when I say we're all in awe of what you did, and this is an incredible document that we read and reread to our great benefit. So I think now, are we going to light?
So who's the grandchildren?
So are the two grandchildren of Chief Justice Verma in the room?
Yes.
So could they stand up, please, and ideally with a pair of matches in their hands, so we can light the tribute. No matches. Does anybody have it? Oh, they're on the table. So would you come forward, please? And just here, there's a gap in the tables. Thank you so much. Yes, I think Mr. Sorabjee is suggesting we just observe 1 minute of silence. Maybe that's a wonderful idea. So why don't we proceed to do that? Our keynote speaker today is Soli Sorabjee, the former Attorney General of India. Pardon? Oh, you're introducing him?
No. She's an that is just as Leila said.
She's speaking. That was part of the training.
Oh, I'm so sorry. Okay, so I'm looking forward to your speech in that case. Sorry, this is a misunderstanding. So Justice Leila Seth is going to now give her speech first, and then Mr. Sorabjee will follow. Okay, apologies.
Friends, in the words of Pratap Bhanu Mehta in his article, By Her Yardstick, Indian politics is becoming a circus trying to stymie profound social changes. Politics is important, but we also need to redirect energies to thinking about the deep undercurrents that will shape us. The gender revolution is the most important. End of quote. How do we set about creating the momentum for a quicker gender revolution and the ethical maturity of our society? We need to harness all our forces. We need to start by changing our attitude, and this can only be done by collaboration between the family, the community, and the government. The media, both print and electronic, are powerful tools and useful handmaidens to bring about this awareness. Programs like Amir Khan's Satyamev Jayate, shown on both Star Plus and Doordarshan, would go a long way in spreading the message. Laws need to be strengthened and implementation made more effective, and the judicial process speeded up. Government policies and incentive schemes need to be simplified and more focused. Education is the tool and the road to empowerment so that girls are both emotionally and economically independent, and marriage is not the be-all of their existence. It is important to communicate and highlight successful stories of girls who have taken care of their families so as to break the tradition and culture of son preference. As Mary Spade said, every child needs an equal opportunity to struggle. We must not allow politicians and others to be lax about accepting what Khap Panchayats and others are trying to do to reverse the trend of empowerment of women. We must make sure that the Constitution of India is given due importance and is followed in letter and spirit, and the laws implemented. Both men and women have to speak out. Working women will be more confident because they are not economically dependent and will get respect even if it is given grudgingly. In fact, each one of us needs to speak whenever we see discrimination and injustice. For in the words of Martin Luther King, our lives begin to end the day we remain silent on things that matter. Much has changed for the girl child during this period of 65 years since India's independence, but not enough. I am hopeful that things will change fast now. As Victor Hugo said, there is one thing stronger than all the armies in the world, and that is an idea whose time has come. And I would add, stronger than the Khap Panchayats and their firmans. And they too can be persuaded to change their ideas and decisions. So I'm confident that by the time we celebrate our platinum anniversary, 75 years, there will be equity, equality, and justice for the girl child. You may wonder why I talk about the girl child and not women. The reason is that one should start at the very beginning, from where the problem arises. After years of discrimination and uncaring exploitation of the girl child, we cannot allow it to continue. The government has to ensure that it stops, and we have to ensure that our mindset is changed and tradition is not allowed in to delay it. We have to increase the momentum on making people aware of the human violations, making them assert the rights of the girl child, and taking action. The girl child cannot wait silently till tomorrow. Equality is most important, but the greatest inequality is treating unequals as equal. Can we treat an uneducated girl as equal to an educated girl? No. We must try and make them both equally educated before treating them equally. Can we treat an economically empowered person on par with one who is not economically empowered, nor has the capacity or training to become one? This would be unjust. When there is inequality and injustice, there is oppression, and we cannot have such a society. It is our duty to mold our future society in such a way that there is equality. There are so many evils and aspects of violence and discrimination, such as human rights violations, dowry, domestic violence, sexual abuse, unequal laws, gender injustice, etc., etc., that it is not possible to deal with all of them in this lecture. I have therefore decided to deal with just two: the right to be born and nurtured, and marital rape. As is more than apparent, girls have not been treated equally despite our constitution and changes brought about in laws. On the one hand, they are worshipped as devis, and on the other, the female fetus is indiscriminately destroyed. A survey done in Mumbai some years ago found that out of 8,000 abortions, 7,999 were female fetuses. The sex ratio is adverse. The number of females per 1,000 males is 914, according to the 2011 census, down from 972 in 1901. It has been slowly going down. It was 945 in 1991, 927 in 2001, and now it is, as above mentioned, as low as 914. The 2011 census revealed that there are about 7.1 million fewer girls than boys in the age group of 0 to 6 years. A few years ago, the famous economics Nobel laureate Amartya Sen had asked, "Where are the missing women?" From the facts indicated above, there are over 7 million missing women in India. So between female feticide and infanticide and neglect of the baby girl, we have destroyed her right to be born and her right to be nurtured as a child. Some years ago, infanticide was more prevalent, but with the development of science and technology, amniocentesis, and the ultrasound techniques, feticide has taken over. This imbalance between girls and boys aged 0 to 6 years, as indicated in the 2011 census, is very unfortunate and shows the reluctance of Indians to have daughters and to neglect them if they are born. So how do we change this patriarchal mindset? Changing the laws and making sure they are properly implemented is one aspect, but that is not enough. We need to make a multi-pronged attack. We need to use advocacy. In South Korea, which was a rigidly patriarchal society, there is now a change in thinking. Apart from the socio-economic development and changing the laws of inheritance, a multi-pronged attack was mounted, and campaigns featured popular slogans such as "One daughter raised well is worth 10 sons." We have to get rid of the son preference in our country, which is encapsulated in expressions and blessings like, "May you be the mother of 1,000 sons." Changing the mindset is very important because law is only a springboard from which to take off. It is the implementation of the law and the way in which the community adopts it that is relevant. What the girl child is asking for is not something extraordinary. All she wants is a fair deal. A right to be born, a right to be nourished and loved, a right to be educated, and a homogeneous environment, a right to choose and a right to excel. In brief, she wants equity, self-esteem, and dignity. Interestingly, in India, sex imbalances at birth appears to be especially concentrated in middle-class families, reasonably affluent and educated families, at least in Haryana, one of the world's affected states. This would indicate that education and development, though very important, is not a sufficient answer. Sex selection feticide and infanticide distort the natural child-sex ratio. The natural child-sex ratio, I'm told, is 105 boys to 100 girls. That's the natural sex ratio. But they say that since girls are stronger, eventually it equalizes to 100 to 100 because girls are normally tougher babies. We can only change the mindset by campaigning and influencing communities and implementing the law vigorously. Women must be a part of the decision making. Some time ago, I read in the newspapers and saw on television over 200 women in a Haryana village. Appropriately, the village was called Bibipur, taking part in a panchayat along with men and passing a resolution that female feticide is a heinous act and should be treated as murder. Ritu Jaglan, a postgraduate from the village, and her brother Sunil Jaglan, a mathematics graduate, the sarpanch of the village of Bibipur, were the driving force behind the campaign. Over a period of 2 years, they mobilized and sensitized the village through plays, rallies, and door-to-door campaigns. The village now takes pride in families who have daughters. The dynamic young sarpanch motivated the Anganwadi workers, Santosh and Asharani, to go from house to house, spreading the message the daughters are as precious as sons and are as capable of carrying on their family lineage. They also pointed out the health hazards of feticide. This resulted in the change of mindset of the villagers and is a model which can be reciprocated in other villages. In fact, neighboring villages of Haryana, Rajasthan, Uttar Pradesh, Delhi and Punjab are also being influenced. This social change is now being brought about by the people themselves. It is only when people feel that they have taken the decision do they feel responsible to ensure that it is implemented. This is certainly a big step forward. And I am happy to note from the Times of India of yesterday that Haryana's Khap Panchayats, notorious for routinely ordering honor killings in cases of intercaste marriages, have come up strongly against sex selection and female feticide. A cluster of 20 villages in Jind district held a meeting in Tuha village and made a commitment to improve the sex ratio. This was because the skewed sex ratio had forced villagers to look for brides from states like West Bengal and Jharkhand, and this had created many problems. They also urged villagers not to give or take dowry, so that girls are not considered a burden on the family. While dealing with sexual assault, molestation and rape in our report, Amendments to Criminal Law, popularly known as the Verma Committee report, we had discussed many matters, including the fact that improvement in infrastructure, living standards, sanitation, health and education facilities, and family was very important. One of the hotly debated matters was marital rape. This has to be looked at in the historical perspective and the principle of patriarchy. The offense of rape was originally based on the idea of theft of a man's property. A woman belonged first to her father and after marriage to her husband. So if anyone had sexual intercourse with her before marriage, the father's right and honor were affected, and after marriage, the husband's. Her modesty had been outraged. Even according to the English common law of curvature, a woman was deemed to have consented at the time of marriage to having intercourse with her husband at his whim. In 1736, Sir Matthew Hale declared that a husband could not be guilty of rape on his lawful wife, for by their mutual matrimonial consent and contract, she had agreed to this. and this consent she cannot retract. 1736.
Exactly.
The situation has changed drastically since then. The question of a woman's autonomy and bodily integrity are concepts that have developed over the years, making rape into an offense against an individual where consent is an essential concept. In England in 1991, Lord Keith, speaking for the House of Lords, declared, "Marriage is in modern times regarded as a partnership of equals, and no longer one in which the wife must be the subservient chattel of the husband." The European Commission of Human Rights also endorsed the conclusion that a rapist remains a rapist regardless of his relationship with the victim. The very essence of the Convention on Human Rights is the respect for human rights, dignity. In South Africa, marital rape was criminalized in 1993. In Canada, too, it is a crime to rape your wife. In Australia, in 1991, the common law fiction of irrevocable consent was roundly rejected by Justice Brennan, who said, "It has always been offensive to human dignity and incompatible with the legal status of a spouse." These jurisdictions have also recognized that consent is most important and cannot be implied, and that marital rape cannot be considered a lesser crime with a more lenient sentence. Consequently, we strongly recommended that the exception for marital rape be removed, that the law ought to specify that a marital or other relationship between the perpetrator and victim is not a valid defense against the crimes of rape or sexual violation. The relationship between the accused and the complainant is not relevant to the inquiry into whether the complainant consented to the sexual activity. The fact that the accused and victim are married or in another intimate relationship may not be regarded as a mitigating factor justifying lower sentences for rape. Despite our strong recommendation, the government did not agree to make marital rape a crime. Many men sniggered, and voices were raised against it, including patriarchal insensitivity and the likelihood that it would be misused. Another factor that was bandied about was the difficulty of finding evidence in the bedroom. But this is rather strange when sexual abuse has been defined as an act of domestic violence in the Protection of Women from Domestic Violence Act 2005. Some people raised the bogey that it would result in unnecessary breakup of marriages. But the reality is, it would have been an enabling provision where a woman would have had a choice to lodge a first information report against the husband if she felt things were going out of hand. Under the provisions of the new Act 13 of 2013, the police would have been duty-bound to register it. However, Act 13 of 2013 still contains the exemption. Exception 2 in Section 375 of the Indian Penal Code reads, "Sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape." I am of the view that the non-removal of this exception, despite our very strong recommendation, is unfair to women and violates her dignity and bodily integrity. It is against the spirit of human rights and the Convention for the Elimination of Discrimination Against Women. Is a woman bound to be bound by the feudal fiction of irrevocable consent the moment she takes the marriage vows? Can she never be a woman with her own self-respect and individuality? With one breath, the government talks of encouraging women, empowering them, and enhancing their rights, and with the other takes away their right to refuse sexual overtures. The government has failed to do the right thing by women and been overpowered by patriarchy. However, women should not lose heart. The change will come in time, I hope sooner than later. We need to educate people about the constitutional right of equality. As Professor Sandra Fredman of the University of Cambridge said, that awareness programs must be provided to ordinary people so that marriage should not be regarded as extinguishing the legal or sexual autonomy of the wife. Sexual intercourse and sexual contact is in certain circumstances a pleasurable experience. As such, the question of consent and choice is of paramount importance. In order for it not to be a crime, the consent has to be unequivocal and voluntary. But can adolescent minors be allowed to indulge in teenage romance? This question was also raised in our discussions. We felt that persons who are 16 years and above can have consensual sex, and this consensual sex should not be criminalized, as adolescent sexual activity is a reality. In fact, this was the position till the Protection of Children from Sexual Offences Act 2012 was passed in mid-2012. But unfortunately, the government did not accept this recommendation. This despite the fact that the law as it now stands does not criminalize a man if he has sex with his wife who is above the age of 15 and below the age of 18, with or without her consent. I read in the Times of India of yesterday that the public interest litigation has been filed in the Supreme Court, which has been entertained, wherein it is prayed that even in the case of marriage, sexual intercourse should take place only after 18. Many of our recommendations were not incorporated in Act 13 of 2013, though some were, such as voyeurism and stalking. We were glad to note that an acid attack, throwing or administrating acid, had been included as a specific crime in Bill number 130 of 2012. We had heard horrible stories of a man stalking a woman, and if she objected or turned down his advances, he would throw acid on her face, thus destroying her self-worth and esteem, and completely ruining her life and causing permanent psychological damage. Consequently, we felt that this might have been averted if stalking were clearly an offense and the matter was nipped in the bud. It would also ensure the security and safety of women. So who is a stalker? Any man who follows a woman and contacts or attempts to contact such a woman to foster personal interaction repeatedly despite a clear indication of disinterest by such woman. The law provides that this monitoring by a man can also be by use of the internet, email, or any other form of electronic communication. We are happy that this recommendation imposing a punishment of 3 years in jail and a fine was accepted, and learned from the Hindustan Times of 14th June 2013 that a couple of cases of stalking are being reported every day. I also read recently in the newspaper that the government is thinking of making some provision for regulating the purchase of acid, as has been done in Bangladesh, where as a result acid attacks on women have substantially been reduced. These are positive steps. We need to ensure that an evil like female feticide, which prevents a girl child from coming into existence despite laws, is not perpetuated. We also need to ensure that an evil like marital rape, which attacks a woman's bodily integrity and destroys her choice, is not allowed to flourish, and a suitable law is passed. As Charles Kettering said, we should be concerned about the future because we will have to spend the rest of our lives there. Thank you.
Thank you so much, Justice Seth. I'm so glad that I didn't cut you off entirely. That was a wonderful speech, and wonderful to hear your very strong defense of the criminalization of marital rape, which I think many of us would wholeheartedly agree with. So our final keynote speaker is Mr. Soli Sorabjee. Probably needs no introduction, but he was the former Attorney General of India and one of the most outspoken civil liberties and human rights figures, I think, in India for many decades. And we're delighted that he's agreed to give the keynote at this important meeting. So thank you so much for joining us.
Thank you. Dr. Jacqueline, Bhabha, just as Rita says, my good friend Gopal Subramanian, ladies and gentlemen. Well, actually, I'm not going to give a very erudite, solemn keynote address. I'm only going to make some observations on the two elements of this seminar, of this conclave: gender justice. First, justice. Well, justice is the aim and aspiration of every civilized society which respects the basic human rights of every individual, irrespective of race, religion, caste, sex, or sexual orientation. Justice is the signature tune of our Constitution. Justice, economic, political, and social. These are so beautifully expressed, articulated in the preamble to our Constitution. Now, gender justice has many dimensions. An important component is protection of sexual assaults on women. Rape is the worst form of sexual assault. It attacks the physical integrity of a woman and causes severe, irremediable consequences which affects her mental capacity, integrity. Now, it's really alarming to hear of the increasing incidence of sexual assaults on women in town and villages, irrespective of age. This menace has to be fought vigorously and relentlessly by enacting laws which ensure swift trial and provide for stringent punishment on the offender, on the perpetrators. See, what happens? Delays in trial often leads to disappearance of evidence. Witnesses turn hostile. And because of this and other factors, in many cases, it ultimately leads to the acquittal of the accused, the rapist. This generates an atmosphere, a culture of impunity. You see, thing is, rape ka charge kiya, chalega 5 saal, 10 saal, nothing will happen after that. There won't be evidence, there won't be witnesses, nothing is going to happen. This must be, this culture of immunity, this notion of immunity must be demolished. And frankly, this is one of the main causes for the increase in sexual assaults. Of course, a swift trial must also be a fair trial, in which the basic elements of due process are observed. However, gender justice must not be confined, to my mind, to laws to prevent sexual assaults, and in that direction, they're extremely very important, no question about it. And here I may pay my tribute. I mean, all I've done is, but I would like to pay my small tribute, humble tribute, to the Justice Verma Committee report. Now, I may mention one thing which you may not know, which possibly Justice Verma's granddaughter knows, that every Saturday at 8 o'clock, on which my second cup of coffee, I'll be having a telephonic conversation with Justice Verma, and then he would start, "Kya bhai, kya bahal hai?" And then we talk about it, and I feel so bad. Even now, sometimes I pick up the phone to talk to him, but I tell, oh, he's no longer with us. And the thing about this is the amount of thought, the labor, the industry which has gone into this report, I think is unique. I've never known of any commission, it's not a committee actually, producing a report within the stipulated time. In every case, there has been an application for extension of time. Hey, something has happened. They did it one day before the stipulated time of 30 days. And for that, I think members of the Verma committee deserve great plaudits. Now, as I said on this, we must not gender justice to preventing sexual assaults, providing stringent punishment. I think an important component of gender justice is empowerment of women. That has many aspects. The most important aspect is the economic empowerment. Then educational empowerment. Then, of course, political empowerment. One element is reservation of seats in parliament and in state legislatures for women. Controversial, but this is a real important political empowerment. The prime requirement to my mind, friends, is a change, a transformation of the social attitudes, namely our mindset. All those, nothing will work effectively unless you change this mindset. It's a tragic fact that in our male-dominated society, a woman is relegated to a secondary and inferior position. General attitude of male superiority and domination persists. And the mindset, this mindset must fundamentally change. And what I want to tell you is this, and this is the worrying part. This mindset doesn't only prevail in village panchayats or among khaps. It's even amongst the affluent, so-called educated sections of society in urban towns. I know one thing. Person wants to make a will. In 9 out of 10 persons in his bequest, the son will get more than the daughter. Jackie knows it. It happened in a case of my own grandfather, maternal grandfather. That's still the thing. The man is very educated. He's very enlightened supposed to be. But when it comes to it, daughters will get less, the sons will get more. Among some other people. Another thing. Look at this other mental setup. I remember I was flying in an airline and there was a lot of turbulence and the aircraft went up and down. And the man next to me seemed very worried. And anyway, these things happen. The captain is a bone. Right? The captain of the aircraft was a woman. So he got more worried. Now what do? Unless you change this stupid mindset, I mean, how will you go along with other laws? Laws are important, no question about it. But effective implementation of laws will happen when you really change this mindset. And then when I said it's all right, women are in fact more important than men, she has experienced much turbulence elsewhere, she'll be safe in her plane. Now, it will be a hard struggle. Now, I talked to many people about people in jail, civil liberties, other things. Then there were a group of women, and I talked about marital rape. So they looked at me. I mean, they thought, what is he talking? What marital rape? They thought I was some stupid man, some person from the other planet. So I quickly had to change the topic. They just could not understand how can they be married and raped by a husband. See, there's societal factors. Now here, what I'm trying to say is we have to struggle very hard in these cases when you have to really break down certain mindsets which have persisted over the years. It's not an easy task. But let me tell you, it will be a long, arduous struggle, but say not the struggle not availeth. We must go on relentlessly, and after all, attainment of gender justice will be an unremitting endeavor. And we must persist with the same spirit, and if we do, I'm sure we will prevail. Thank you.
Thank you very much indeed. That was a wonderful speech to conclude this opening session. So I think we really have spanned the terrain from some of the nitty-gritty discussions that took place within the committee to the broader picture of prejudice and patriarchy. It was all topics that we'll be discussing. So what I would now invite people to do is just to give us a couple of minutes so we can change the cast of players here, and so that the first panel on law and law enforcement can come and take their place. Thank you very much.
Somebody else. Yes. Some other people are going to sit here.
Yeah, sure.
The panel.
Colin, come.
Our first session this evening on law and law enforcement. I'm very pleased to have a very distinguished set of panelists whom I'd like to briefly introduce in the order in which they're seated. First, Ms. Flavia Agnes is a very well-known women's rights lawyer. She is a pioneer of the women's movement. She has worked consistently on issues of gender and law reforms. She's the co-founder of Majlis, which is a legal and cultural resource center. Her primary engagement has been to provide quality legal services to women and children. Welcome, Ms. Agnes. Our second speaker is also very distinguished and very well known, Mr. Colin Gonzalez. He's the founder of the Human Rights Law Network, one of India's leading public interest law groups. He's a graduate of the IIT Bombay. Mr. Gonzalez started his professional life as a civil engineer, but was drawn into the field of law through his work with the unions in Bombay. He commenced formal legal study in 1979 and litigated his first case while still in law school on behalf of 5,000 workers locked out of their jobs. Welcome, Mr. Gonzalez. Our third speaker is Ms. Shazia Ilmi. Shazia Ilmi is an Indian politician and social activist. She was a well-noted TV journalist and TV anchor in Star News before joining social and political activities. She was the leading spokesperson for the India Against Corruption movement, led by the veteran activist Anna Hazare in 2011 and 2012, and led a vibrant and highly visible media campaign for an anti-corruption bill, popularly known as the Gopal bill, which captured the imagination of millions of Indians and became a widespread protest across the nation. She has been declared Aam Aadmi Party candidate from the RK Puram constituency for the upcoming Delhi Vidhan Sabha 2013 elections. Welcome, Shazia. And last but not least, our speaker, Ms. Diane Rosenfeld, lecturer on law and director of the Gender Violence Program, Harvard Law School. She teaches courses on Title IX, Gender Violence, Law and Social Justice, and Theories of Sexual Coercion. In addition to teaching, she directs the Gender Violence Program and supervises students in conducting cutting-edge legal policy analysis on issues such as prevention of domestic violence, homicide, addressing campus sexual assault, and new law enforcement approaches to address sex trafficking. Welcome, Diane. We'd like to proceed. We've asked each of the speakers to give a presentation of approximately 10 minutes. Then we'll open up the floor to discussion. It's meant to be an interactive discussion, and we'll proceed with questions and answers after that. Please, Ms. Agnes.
Thank you, Verma. I'm very happy to be here. Making this small presentation. Actually, there are very few people who have been in the whole anti-rape law reform campaign from the Mathura till the 2013. And I'm one of the few who have been consistently with the issue, along with the issue of domestic violence, which is also much more personal for me. I'm a lawyer, and we have a group of women lawyers who help to take women to court, mainly in the area of matrimonial law. But more recently, we've started also a victim support program or survivor support program, not because of the Delhi gang rape case. 2 years before, at that time, it did not have validity or legitimacy, but in some sense, post-December, issue of rape is in the forefront, issue of domestic violence is little receded. So there's a lot of focus on our work, and hence, and also this conference is an outcome of that. So I'm happy to be able to say whatever I have to say. whatever I say may not be with the grain, and you will excuse me for that because it comes from my ground level experience and from my courage of conviction. It's a little difficult to go against the grain, but I think in this forum, I think it's a good opportunity to speak whatever I really feel very strongly. In 1980, when Mathura case, I don't know, many of you were not born that time, many of you were not aware of the Mathura case, but for us, that's a big catalyst for even articulating the word rape. And that time it was a Supreme Court ruling, and the girl who was raped was 16 years, almost minor, and issue was whether she was minor or not, and she was raped by policemen on duty while she was taken to the police station. And first the Sessions Court and later the Supreme Court held that since there were no marks of injury, she cannot be raped because consent indicates or non-consent indicates injury. So for a long time we've been with this concept that rape means a struggle, and the struggle must, and penetration, and a complete penetration at that. And from Mathura onwards, and we got this amendment, stringent punishment, burden of proof shifted in selective situations of custodial rape, etc., etc. Actually, ground level, nothing changed. All of us campaigners felt very happy. We had moved the state machinery, we had moved the criminal legal system. We were a handful of people protesting, 50 people here and there, labeled as feminists and homebreakers, etc., etc. But it was a great moment for us because we were able to change this huge, massive structure called IPC, which was framed in 1860, to this extent. And all of us went back, had our own things to do. Some of us stayed with issues, some of us went on to other issues. Many more issues became more fashionable in the coming years and decades. And rape somehow receded in the background. Till now. So-called Nirbhaya, which I refuse to call the word Nirbhaya, and I'll come to that later because she has a name, she has an identity before a vagina was torn apart by these brutes. So my question here, the first point I would like to say is this issue was discussed, it was happened when the parliament was in session. Next day there was discussion, everybody was anguished. And we have Sushma Swaraj saying here, you know what happens for a girl who is raped, she becomes zinda lash. She is as good as a dead person. And here we were, for zinda lash, that means she is alive but she's like a corpse. She's dead. That means when we say marriage, I like Justice Seth's point that everything is related to marriage. Presumption being, and it is there in our judgments, vagina is the most precious possession of an Indian woman. And if the vagina is violated, you are doomed for life because then you can't get married. Or judges give compensation because now she's been violated. Now she would need more money for dowry because nobody is going to marry her. Now the link to marriage and virginity, sexuality, agency, and a state worse than death. Now again in the 2012-13 protest, consistently it was said that a rape is worse than death, so we need death penalty. Anybody rapes must be, it's like murder, it's like worse than murder, worse than murder. We have hundreds of women or thousands of women who are killed in their own homes as for dowry or for any other reason. But we never think marriage is a very dangerous terrain for my daughter to enter into a totally alien space. But here, a moving bus can be danger, school can be danger, anything can be danger, and I will protect my child from that stage worse than death by keeping her inside, by protecting her even more till she's married. So this whole question of marriage and virginity, according to me, even the 2013 amendment or the entire report to a certain extent tries to address it, but it doesn't really address it to that extent. So I'm glad when Judge Seth said that, we need to question marriage. So what is it about rape that puts, and vaginal penetration, that puts it in a pedestal for a woman's being. And unless you question that, cannot come to anything flowing from there, then if she is violated, we cannot use her name. It was because of the way the media was intruding in the person's privacy, in a way the courtrooms became a humiliating place where the media reporters would be there. In the judgment, that girl's name would be there for many years, that the name should not be mentioned in the media, etc., etc. But today, about this girl, we know everything about her. We know her inside, we know her outside, we know her friend, grandmother, grandfather, village, everything. And she's dead. Yet, for us, it still becomes important to have this word Nirbhaya. Even though her father, mother says, yeah, you are creating a fund, you're making a law in her name, please use the name. But for us, she does not exist as a person. For all of us, even the enlightened ones, she doesn't exist as a person till her vagina was violated. But then we have another girl in Mumbai called Pallavi Purkaista, who is the daughter of 2 IAS officers, and the watchman went into her house soon after and attempted to rape. And she struggled, whatever, and she died. But since her vagina was never violated, we can use her name. Because the chastity is never violated. Or we can have Acid, Preeti Rati and other people whose faces demolished and then they die. We can use their name, we can put their pictures. But this woman then becomes for us, all of us collectively create a image of something worse possible, worse than death, whatever possible, a gruesome kind of violation. I just want to give you here 2 examples of more recent cases. One is a allegation of rape by a very established Parsi doctor. Parsi is important here to mention. Whose father, Sunamala, was a very famous gynecologist, with the result that not only all Parsi babies, but also other babies would be born through Dr. Sunamala or his children, 8 children, family members, everybody is a doctor or gynecologist. The rape happened. Now there are